So, thank you very much. What I would like to talk about is the current situation in the United States with respect to biotech and pharma patenting, but from a very basic, almost superficial perspective. I've been struggling to try to figure out why is it that the US is doing what it's doing, and have come up with certain theories that probably bear no legitimacy whatsoever, but I nevertheless want to share those kind of theories with you. It's really kind of an understanding of what makes the US tick with respect to new developments in the law, particularly with respect to an area of the law that is so important, not only intellectual property being so important, but particularly the area of biotech and pharma patenting. And what I'd like to do is to divide the talk basically into two parts, to talk about the current case law that you've heard several times already during the course of the presentation, but then also to talk about the Trans-Pacific Partnership and some of the provisions that have a direct relationship to pharmaceutical and biotech patenting. When I look at the situation and try to figure out how did we get to the current situation with respect to the Mayo case, the Myriad case, and the newest case to come out of the Federal Circuit, the Ariosa case, it seems to me that in order to try to get an understanding, you have to look at the very basics of US patent law and how we define a patentable invention under the law. Because our way of doing it, I believe, is, if not entirely unique, at least fairly unique. So you're all familiar with US Section 101 of the patent law, which defines a patent, defines an invention as any new and useful process, machine, manufacture, or composition of matter. That part is so far fine. But what we lack, what most countries have, is the sort of corollary provision, which is what doesn't constitute a patentable invention. We are totally, the law is totally silent, and as a result, we need to rely on the judiciary to determine what the exceptions to patentable subject matter are. Just to point out, as you are aware, the European Patent Convention has exceptions. The Indian Patent Act wins the prize, probably, for having the most exceptions. You could criticize the Indian Act for having perhaps too many exceptions, but at least you know where you stand. We don't in the United States. Even the TRIPS agreement has Article 27, which grants basic rights, but then also grants exceptions. So in the US, what we have to rely on are the judicially created exceptions to patent-eligible subject matter, to laws of nature, to natural phenomena, and to abstract ideas. These aren't patentable because they are the basic tools of scientific and technological work, and granting a patent might tend to impede innovation more than it would tend to promote it. But again, these are pretty vague and open-ended terms, and it almost creates an inherent tension in the law and in the way we apply it. Uta mentioned that Justice Alito, who, by the way, is an idiot, and don't quote me on that, but that Justice Alito had said, well, it just goes by the word. I think Justice Alito was not giving full credit. We've created a system where, on the one hand, we have the Court of Appeals for the Federal Circuit, which is a patent-friendly court, and is a court made up of people with specialized knowledge. It's a specialized court. But then we have the Supreme Court as the ultimate arbiter and decider, and very specifically, they are not a specialized court. And their job is not only to interpret the word, as Justice Alito had said, but really to sort of place the law, place the interpretation of the law within the context of of current thought, current policy, certainly of current public policy. And when you look at the area of patent-eligible subject matter, you kind of, at least I think, sort of see it in a very apparent level. If you start by looking at the Chakrabarty case, which, as you know, was sort of the case that invited the fullest scope of patenting, the case that said that everything under the sun is patentable, that was a case that came about at the beginning of sort of the real rise of the biotechnological revolution in the United States. And as a matter of sort of general policy, what we really wanted to do was encourage as much invention and inventiveness as possible. When you look at the cases that we'll look at now, you see a very different picture. You see a case where, unlike in Chakrabarty, where had the microorganism actually worked and actually did eat up oil spills, it would have done a lot of good for all of society. But if you look at Mayo and Myriad and perhaps even Ariosa, while on the one hand you do see really great progress that came out of those inventions, the way the public perceived it was that had the patents been allowed, a lot of people and the public in general might have been injured, not benefited. And certainly there is no way of knowing for sure how much that contributed to the decisions of the court, but it's possible that it certainly did play a role. So if you look at the Mayo case, what the Mayo court, and by the way, both Mayo and Myriad were unanimous decisions of the Supreme Court, and the Supreme Court currently now is made up more of business-friendly justices than not business-friendly justices. As you know, the invention was a method to assist doctors in determining whether a given dosage level of a particular drug was effective or not based on the concentration of a metabolite in the blood. And so it was really a very important invention that allowed a doctor to make an effective way to make a diagnosis. What the court said was that the relationship is a natural result of the way in which these compounds are metabolized. The claim in the case consisted basically of 3 steps. There was an administering step when the drugs were given to the patients, a determining step when the patient's metabolite levels were established, and then a wear-in step where the concentrations above which there was a likelihood of harmful side effects became apparent, and it allowed the doctor to adjust the dosage levels in accordance with those results. All that so far is great. And based on these patents, Prometheus developed and sold this metabolite blood test. Mayo, the primary, the most well-known and recognized medical center in the United States, used the test, but then it developed its own. And when Mayo said that it was going to market the test, Prometheus sued for infringement. So if you look at the case as a story, which I think is very important, what you see is a company blocking the leading medical center in the US from, in fact, making improvements upon and advancing a drug test that is going to help patients throughout the country. And so in that case, when the case came to the court, the issue became whether the claims were patent eligible or whether they constituted, in fact, a patent ineligible law of nature. And as you know, the court found that the claims weren't patentable because they set forth laws of nature, really just talking about, from the court's perspective, concentrations of metabolites in the blood and the likelihood that a particular dosage would prove ineffective or not. So it was taking a law of nature, taking an ordinary sort of analytical view of it, and coming up with, while an important decision, important result, not a patentable result. And what the court said, that if the law of nature itself isn't patentable, then the process that merely recites the law of nature is not patentable either, unless that process has additional inventive features that the court didn't find were present in this case. And in fact, if you look through the court's decision and pick out some of the words that the court used to justify their decision, one of the lines, one of the sentences that struck my attention the most was the notion that they said that, that if in fact this patent had been allowed, they would tie up the doctor's subsequent treatment decision, whether that treatment does or doesn't change in the light of the inference that the doctor has drawn using the correlations in the case, and they threatened to inhibit the development of more refined treatment recommendations. So it was almost, if you look at it from this perspective, a consideration of, would this patent in the end do more harm than good? And it obviously couldn't end just there, but it went on to try to provide a test that talked about what can make a law of nature patentable, and that it would really depend on how that law of nature is applied. That if there is in the Mayo case, a novel and a useful structure that's created with the knowledge of that law of nature, then that can be a patentable invention. But you can't make an unpatentable law of nature into a patentable invention just by saying you're going to apply it in some non-inventive way. In the Myriad case, what you really had is the same thing, but even more so. And I'm going to jump over this very, very quickly because I also see that my time is running out. But that if you needed to look, again, looking at this case as a story, if you needed to look for the poster child of patent abuse, the poster child of a company that was trying to perhaps take undue advantage of a patent from a public perspective, from the way that the public viewed, the Myriad case would be the case in point, and Myriad Genetics would be the company that would be that poster child. And I hope there's nobody from Myriad who's in the room now. Myriad isolated two genes that were both associated with breast ovarian cancer, BRCA1 and BRCA2, and that was great. But then they created a test, and they also claimed exclusive